Hey, out there, legal warriors. I want you to protect yourself with knowledge from this video. If you or anyone you know has the first court appearance for a DUI, how do you protect yourself? What should you expect, and what do you have to look out for if you're going to court for the first time for a DUI charge in Washington State? If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. In this video, I want you to protect yourself because there's a lot of bad things that can happen at a first appearance for a DUI in Washington State. And when I say first appearance, I'm talking about a charged DUI case where you've been summoned for something called an arraignment. An arraignment is where a criminal defendant enters a plea of either guilty or not guilty. There's a prosecutor there, there's a defendant there, hopefully there's an attorney there on the defense side, and there's also going to be a judge. And at this arraignment, all criminal charges start with an arraignment, but there's some particular issues that the judge has to consider at a DUI arraignment in Washington State. In fact, the issues are so important that if someone's charged with a DUI or arrested with a DUI, certain conditions have to be considered by the judge in most cases before somebody can be released for a formal charge for DUI. And let's just get into what the court needs to look at and what you should worry about if you are that defendant charged with DUI showing up in court. So for the most part nowadays, you're going to have to appear in person for a court appearance for an arraignment for DUI. Now look at your court notice if you have one and call an attorney or a court if you have to. But nowadays, I'm filming this in March of 2024, arraignments are back in person. For the last 2 or 3 years, arraignments have been by video. Now, for the most part, they're back in person, which means you're going to go to the courthouse, you're going to find your courtroom, and eventually the court is going to call your case. When they call your case, they're going to have the prosecutor read out the charges. You'll have a chance to waive a reading of the charges so they don't have to read them all to you. Then the court's going to let you know, hey, you're charged with DUI. The maximum penalty is a $5,000 fine and 364 days in jail. They're going to tell you what your mandatory minimum penalties are based upon your breath test, refusal of a breath or blood test, how many prior offenses count within the last 7 years, and then they're going to take a plea of guilty or not guilty. Of course, you're going to plead not guilty, and then the court is going to look over to the prosecutor and say, hey, prosecutor, what conditions do you want to protect the public while this case is going on? And the court is supposed to look at certain things. They need to look at an offender's prior criminal history altogether, or for DUI. When they're looking at a prior criminal history altogether, they're looking for violent offenses. They're looking for how many offenses have happened overall in the past. And they might even ask the prosecutor for any out-of-state information on a nationwide background search to see what a person's criminal history is, because the court is supposed to protect the public from violent offenders with the conditions that they set. So the prosecutor is going to say something along the lines of, I want standard conditions. That's good news. On a DUI, standard conditions would be no driving without a license and insurance, don't drink or consume alcohol, stay in contact with your attorney, appear for all court dates, update your address, stuff like that. Or they might want worse things. What might they want? What do we want to know about? Well, if you have a prior DUI offense any time in your lifetime, the way the law is currently in Washington State, even 15 years ago, even a DUI that got reduced to a lesser charge, now the law says that the court has to be extra worried about you if you're back in front of the court, no matter how long ago that past offense was. The court is required at a minimum to order you to put an ignition interlock device in your car if you have a prior offense. And if you don't have a prior offense, they can still do that discretionarily. the prosecutor can still ask for it if they think you got a high breath test or a traffic accident or other aggravating factors like passengers in your car. And some courts sort of hear that request routinely, like Seattle Municipal Court. Almost every case they're asking for an interlock, it seems, if you ask me. Other courts as well. Some of the courts in the northern counties seem to be a little harder on that. Some courts are ordering you not to drive during hours of darkness. I won't name the court there to protect the innocent. But the prosecutor's going to ask for what they want, and the court is going to look at that prior criminal history, including prior DUIs, to decide what to order. What else is the court supposed to consider? They're supposed to consider your history of failure to appear. They're going to look back on their system and see how many times have you ever missed a court date? Have you ever had any warrants for your arrest? And if you have missed court dates in the past, that's a reason for the court to think that you might miss a court date in the future. So do they order an interlock for that, or do they order some other type of alcohol device for that? No, they order bail for that. They say, hey, you're going to have to post money to stay out of jail because I don't trust you're going to come back to court. And so if you have a history of failure to appear, then the court may make you pay money to stay out of jail. And if you don't have the money, guess what? You go to jail and you sit there while the case is going on until you post the money. And of course, we have videos on this channel about bail and warrants and how all these things work, but realize that you have to be worried about any prior missed court dates that could make things worse. So let's take an example of another way you should protect yourself. The most common thing that I see where people make mistakes, where I have to correct them if they're calling me on the phone. I'm always glad that they do so I can correct them. Let's say that somebody's in the position where they do have a prior DUI somewhere in their past, even a reduced DUI, and they go to court and the court says, well, I'm going to order you to put an interlock in your vehicle because I'm required to. And the defendant says, well, I don't have a vehicle, or I don't want to put an interlock in my vehicle. I'm just not going to drive. Well, you used to be able to just sign a declaration of non-driving and not worry about the interlock. But the legislature now has made the court order something even worse, in my opinion. If you don't have a car or you don't put an interlock in the car when you're required to, they order 24/7 alcohol monitoring. Now, the most common thing that they order is called SCRAM, SCRAM. It's a device you wear on your ankle that measures basically alcohol that's evaporating off of your body, and it's pretty complicated, but it's really uncomfortable. You have to wear it 24/7. It's embarrassing. It can be painful, and it's very expensive, somewhere around $500 a month for this thing. And it's also not very accurate, in my opinion. It does a bad job because it also registers alcohol in the atmosphere. And there's some safeguards against that, which I won't get into here, but I've seen some pretty bad situations that I've had to fight pretty hard on. I've got an engineering degree in my background, thankfully, to deal with the science and the court not understanding the science of the SCRAM bracelet. They can also order other types of things like handheld devices you have to blow into, every so many hours. You got to wake up in the middle of the night and blow into it. It's also incredibly not accurate. Also incredibly misunderstood by probation departments who don't have any type of science background or understand cutoff limits or things like this. So if you have a prior offense and you're going for an arraignment and you don't have a car, get yourself a car. Get yourself someone where you could put an interlock in their car, please, because you do not want to have these 24/7 alcohol monitoring things. They're expensive. They're dangerous because they don't work very well. When they don't work very well, it's you who goes to jail, even if you weren't drinking. If the court doesn't understand what a reading means, doesn't understand a false reading, or you have an attorney who doesn't understand that, who is unable to help you fight your way out of an unfair system. So what does that mean? It means that when you go to court, you want to make sure that the court understands you're going to return for court dates. The court understands that you're not going to have any more problems. If you've got a very high breath test, you may already want to have an alcohol and drug evaluation scheduled by the time you go to court, so you're less of a risk. And if you know they're going to order an interlock in your vehicle, you could put an interlock in ahead of time to improve your chances of the court not issuing worse options for you, or not even options, worse orders for you, because these conditions of release that the court orders at the arraignment are going to last for the whole case. You can make motions to change them, and if you get a scram bracelet, one way we get it off is, if it's a discretionary one, is to get you into alcohol treatment or get you an evaluation to say you don't need it anymore. But if it's a mandatory scram, the only way to get it off is to get an interlock in some vehicle and then make a motion to take it off. But most cases are going to go 3 months, 6 months, 12 months. So what happens at this first arraignment date is really important because it's going to affect you for a long time to come. And so many people go into it casually. So many attorneys don't think ahead and get their clients prepared so you can get better conditions of release. You know, you have to have worked the system for a long time to understand that being casual about an arraignment is a risk that is not worth taking. So I hope you found this video useful. If so, please like and please subscribe. More people get to see it. And more importantly, if you have a legal problem in Washington State, a criminal matter, a protection order, a DUI, feel free to give my office a call. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.